welcome to 30 Years, 30 Cases video podcast series, a series launched by ERA, Academy of European Law in Trier, to mark its 30-year anniversary with a presentation of 30 landmark cases of the Court of Justice of the European Union. My name is Karolina Rokicka, and I'm an ERA lawyer responsible for EU institutional law topics. Today, we will discuss a famous opinion of Advocate General Jacobs in case C-50/00P, Unión de Pequeños Agricultores against Council of the European Union, delivered back in 2002 on the 21st of March. The case concerned locus standi of private non-privileged applicants under Article 230, paragraph 4 of the treaty establishing the European Community, what is now Article 263, paragraph 4 of the Treaty on the Functioning of the European Union. And more specifically, the interpretation of the notion of individual concern, which was quite severe after establishing by the court the famous Plowman test. Very briefly, what was the case UPA about? UPA was an association of farmers that sought to annul the Council regulation amending the common organization of the olive oil market. The Court of First Instance decided that the members were not individually concerned, as they were in the same situation as any other trader who may enter the market at that point or in the future. In other words, according to the court, UPA had no locus standi under the current treaty. What was so special about the opinion of Advocate General Jacobs and what was the final decision of the court in this and subsequent cases will be explained to you by Krystyna Kowalik-Bańczyk, Professor of European Law and Judge at the General Court of the European Union. Judge Kowalik-Bańczyk, welcome to the podcast and thank you for joining us today. Let us start with the notion of individual concern. What does it actually mean, individually concerned, in this case, in UPA case?
Thank you very much, Carolina. I am very privileged to be speaking to you. Thank you very much for your invitation. And in fact, we are talking about a case that constitutes a highlight, one of the highlights in the jurisprudence of the Court of Justice, because effectively the individuals before the EU courts are a little bit like in the song of Guns N' Roses, knocking at the heaven's door. So they are able to question the validity of legal acts, but it is not easy in terms of standing for them because the door is not very widely open for them. And this very case, UPA case, together with the case that happened a little bit later in parallel, Jego-Kere case, show that some very stubborn individuals, despite perhaps certain problems with the standing, can change the face of the EU law. And this is actually the heart of this issue. But let me start from the individual concern. So as I said, individuals can question the validity of legal EU acts if they are the addressees of those acts, or if they are directly and individually concerned by those acts. And what does it mean in this case to be individually concerned? As you already mentioned, we are applying a test that dates back to the 60s of the last century. So it is an old 60-year-old test, the so-called Plowman test, that indicates that an individual can question a decision or an act that is not addressed to him or herself if they either are peculiar because of some attributes of this individual. For instance, they are the only exporter of a product, or because of some circumstances that are very different for them for any other person. So usually those circumstances are defined in terms of a time where you were either privileged or obliged to do something. For instance, you can indicate that for a certain number of years you were in a peculiar position. So you have to somehow make your situation specific. And this actually means that whenever an individual introduces a case in front of the General Court or Court of Justice, the first issue to be examined is the admissibility of this action. And the court looks very carefully whether this person is, in this sense, specific or particular as to its attributes, as to the circumstances. And in fact, this knocking on the heaven's door is in particular difficult for the acts that are of a general application. If you have an individual act, you can usually show that that you are individually concerned. If you have a general act, it is actually producing legal effects for classes of persons, for broader categories of persons. So usually the door is locked. And what was so peculiar in this UPA case was that after the initial refusal of the General Court in an order from 1990 to admit the case, Advocate General Jacobs decided to try to change this long-standing tradition of Plowman test and argued that this restrictive approach should be criticized and perhaps should be changed. This rebellion was not in the first place accepted by the Court of Justice, but still it was heard and it led to certain modifications in the EU law. So why was this proposal of Advocate General Jacobs so peculiar? The UPA in this very case claimed that the action for annulment should be admitted because of the complete absence of any legal remedies under national law and under European law, this at the disposal of this association of small agricultures. And there was no possibility to question this act of general application because it was not in fact a hidden decision. There was no way to somehow prove this individual concern for the association of agriculture in question. And in itself, this solution that such an association cannot really question this act is not surprising. In the member states, it is usually also the case that this type of acts is not open to legal review at individual application. But within the European Union, such acts are very, very often they complement the legislative acts of more broader application, and they can be perceived as a sort of a administrative act, so open to the review. Advocate General Jacobs gave a very strident opinion, urging the court to change its case law. And in fact, he argued that the national courts are not entitled to declare measures of EU law invalid. And you cannot expect that an individual will try to breach the EU law to have access to the national court and only then question the validity of European Act, because it is too uncertain and it is not in accordance with Article 6 of the European Convention on Human Rights. So the Advocate General Jacobs was mainly criticizing the existing case law, as in the case at hand, saying that you have no legal protection in this type of situation because you are unable to prove your individual concern, and you have by this no legal remedy, be it at the national level or at the European level.
Thank you very much for this explanation. I was wondering, what was at the same time the weakest point of his opinion?
Thank you for this question. Yes, in fact, it is quite a nuisance to speak about the weakest point in the opinion of the Advocate General Jacobs, because the text in itself is very, very persuasive, and it's really influenced the future of EU law. But if I may allow myself to speak about the weak point, it is actually a very simple constatation that the courts cannot change the law, and in particular, they cannot change the competences that are at their disposal. So it is, in fact, something that the Court of Justice stated in its further judgment, that the courts or judiciary cannot ignore the wording of the treaty. And if we look at the wording of the treaty, according to the Court of Justice, the treaty and by the treaty, the member states contributed to the judiciary a complete set of legal remedies for application for applicants seeking to challenge EU law. So in a sense, understanding the argument of Advocate General Jacobs that you need to protect the principle of effective judicial protection, stemming at present also from the Charter of Fundamental Rights, and back in the end of 90s, beginning of this century, from the general principles of EU law, we still need to respect the treaty framework of what courts can and cannot do. So the weak point is that we would be required to ignore this requirement of exposing an individual concern.
Thank you very much for this additional information. It's indeed very difficult to look for any point that could be criticized in his opinion, because as we have said, this is a famous opinion, a landmark opinion, certainly, in the jurisprudence of the Court of Justice. You mentioned earlier a case, Jego-Kere. Maybe it's a good moment to explain us better a broader context. So how was it with the case of Jego-Kere, and actually what happened next in the UPA case?
Thank you very much, Carolina. Yes, you are actually touching the heart of a problem here, because the case that followed UPA, or to be more precise, that followed the opinion of the Advocate General Jacobs in UPA, and that came as a surprise, was the case Jego-Kere against the Council, that was issued before the Court of Justice itself could say if it followed or not followed the Advocate General. It so happened that in May 2002, after the opinion of Advocate General, it was 1 month and 2 weeks after the opinion, the General Court followed Advocate General rather than its own practice. And it actually admitted as admissible an action against a regulation that was changing the fishing policy of the European Union in order to protect the hake, which is a fish that was caught in the fishing area of community, and it was actually to be protected by reducing the size of mesh size. And Diego Carré was a fishing company of French origin that was south of Ireland, fishing for the hake, and it was actually trying to contest the regulation. And it really came as a surprise to everybody observing the development of this case law, because the General Court was, I presume, persuaded that the Advocate General would be followed by the Court of Justice, and it itself admitted a case that usually would be inadmissible. Later on, again, it was a very short time frame. After this judgment of the General Court in Diego Carré, the Court of Justice answered to the Advocate General in UPA case, unfortunately refused to follow his suggestions, and later on quashed the Diego Carré judgment as well. And Advocate General himself, in his opinion for Diego Carré, admitted that as the Court of Justice already ruled on UPA case, it has to follow its steps. But what was actually the most interesting issue here? We did have, I would say, two moments of rebellion. First, we did have a rebellion on the side of Advocate General Jacobs in the UPA case, and then we had a rebellion on the side of General Court in the Diego Carré case. And this rebellion was not accepted by the Court of Justice because it argued that the courts cannot depart from the wording of the treaty. But this very critique was heard by the legislator of the European Union, and it actually was a reason for a change of the wording of the treaty provision that was proposed by the then treaty to constitute a constitution for Europe, that later on was renamed as a reforming treaty, and we all know it as a Treaty of Lisbon. So to be brief, the two acts of admission that were suggested first by the Advocate General and then by the General Court were not followed by the Court of Justice, but the general suggestion stemming from this jurisprudence to change the wording of the treaty happened, and on the 1st December 2009, the new wording of the provision on the action for annulment was containing a new provision allowing for the individuals to contest the administrative acts of general application that are called regulatory acts. And this shows that even an unsuccessful legal action can have an impact on EU law and can change the face of primary law. This said, this of course opens a new and fascinating journey to the following case law on the notion of regulatory acts, but this is not an object of this podcast.
Many thanks. Indeed, with this conclusion, we are leading to the end of the podcast. Judge Kowalik-Bańczyk, thank you very much for a nice discussion we have just had. It was a true pleasure talking to you today. Thank you to everyone for joining us. That was 30 Years, 30 Cases podcast series of ERA.